it and are able to understand it would be given a recognition under respective legislations of the countries. So Article 15, Article 1920 is what we are dealing with in trips about trademarks. So that's there. Now, if you're coming to the Indian legislation, we have the Trademarks Act of 1999, which talks about marks. Section 2M says what the marks is. We're not getting the definition because it's just interpretation. I'm sure you all have gone through it. And 2ZB talks about trademarks. So it says any mark capable of being represented graphically would be given protection under Section 2Z. So the idea is that the mark should be able to distinguish a good and service from the relatively similar goods and services already existing in the market. So it can include shape of goods, it can be a word mark, it can be a label, it can be color, one color combination of colors, and the way the good is packaged, the way the good is shaped. So all of that is what Section 2ZB talks about in the Trademarks Act. Now, so this is what the legal legislation is. We'll try to see things in the Indian perspective, but also try to keep the projects little universal. Trademark is basically any symbol, word, or design that identifies the origin of good or service. Now, why does one need this? Why does one needs this kind of protection? What happens when you have the bread that you have in the morning, the loaf of the bread, doesn't come with a brand, doesn't come with any kind of symbol, doesn't come with any kind of indication. What happens? The bread is a bread, right? So why, in that sense, a trademark becomes important? Uh, you know, I personally think that it's not about the bread, if it's looking fresh or not. It's about from where or from which bakery the bread is coming from. So over the period of time, because I've used a certain good or I have used a certain service from a certain place which has a reputation, which has consistent reputation, goodwill to maintain, I have a trust as a customer in that bakery, or I have a trust in that product. And how do I know which product is mine, which loaf of bread is mine? When I see that mark, when I see that this bakery's mark is attached to that kind of bread or loaf. And this is essentially what the reasoning of intellectual property's trademark is. So, I mean, why it matters? So, in terms of businesses specifically, it's a strong brand-driven thing. Trademark actually protects your brand. It protects a brand's identity, and with the trademark, the brand can monetize more efficiently and in the intangible format of the market. So, and how can one do that? One can do that monetization of the assets via assigning, via licensing, via franchising, you know. So that's it. Having said that, a trademark can be registered and cannot be registered. And I'm telling you this because in Article 15, we were just mentioning what TRIPS Article 15 says. It says that registration is not a mandate. So Article 15, because it keeps registration non-compulsory, India also follows the same. So we say that registration, if you register, it's well and good. If you don't register, the violation of the trademark that you have would be then governed by the common law system and would be, if someone violates that right, it would be called passing off. And if someone violates a registered trademark, that would be called infringement. So that is why, it's very important for one to firstly register a trademark because it relatively gives you an easier ground to make your claim. And this will also help you monetize your asset more efficiently. So that's why it matters. I think the strong brand drives business values and trademarks protect the brand identity. So that's roughly going to be our session today. So just coming to what trademark licensing is. So a trademark license is generally governed by Section 48 of the Act, which talks about registered users. So it's simply a permission. It's a permission by the owner, who is the licensor, to the licensee, somebody who's going to be using the license or another party to use the mark. Understand that licensing, ownership doesn't change hands. Ownership still lies with the licensor. What he has given is the right to use the trademark the right to use the trademark, but not claim the ownership of the trademark. So the licensee will have no right to imply in any of the ways to the customers or to the market or to anybody else that he or she is the owner of the trademarks. This is the first thing that we hear about licenses. Now, licenses can be of various types. Licenses can be exclusive, non-exclusive, sole licenses. Who is a sole licenser? Sole licenser is essentially somebody who uses a license as an exclusive licenser only. But the only problem is that the owner can also utilize the license as opposed to an exclusive license. In an exclusive license, um, the owner can also be stopped from using the trademark because the licensee is the only person who, for the time period, whatever time period they have decided to, use or put in the agreement, will be allowed to use the trademark as a mark and not the owner himself or herself as well. So these are and the non-exclusive would mean, giving license to multiple people, and yeah. So this is what forms of licenses that we have. Um, so again, as I said, Section 48 allows any person other than the owner to be a registered user for certain goods and services, and to formalize this, the owner and licensee must need to file and have a written agreement, license agreement. That the agreement must be in writing and it should be filed within 6 months in front of the trademark registry. And there's a form which TF48 which needs to be fulfilled. And while unregistered marks can also be licensed under contract law, but only registered marks can be registered in the registry. So I hope with respect to license, the basics are a bit clear. Now, in contrast to licensing, franchising is also something that we look into. It's not completely in contrast, but it is an addition. While in license, the person only gives you the right to use one's IP. In franchising, a commercial model that includes a trademark license, plus the business know-how, business support, and the training of the business is also given along with the IP, which is the trademark here. So for example, let's just say a famous brand like Domino's, there's a certain way they would make their breads, there's a certain way they would make their spreads for the pizzas. So what do? They not only give you a franchisor, their logo to use, but they also tell you how exactly will you be using the products. There's a certain way you need to make these products so that um, man uh, man labor has been taught how to use that kind of work. So that's there. So that's what we talk about franchising. So that's what we mean by franchising. That there's no specific franchising legislation in India. So again, in India, it is otherwise governed by general contract or by business laws, or if it's a trademark violation, it will also come under the IP headings. So this is formally what do we mean by franchising and what do we mean by trademark licensing. Um, so if you have any quick questions to ask, you can always put it on the chat and I can see it from there. Now that we've discussed what do we mean by trademark, what do we mean by the licensing of trademark, how is licensing different from franchising, I would just go ahead and universally tell you what all you need to include in your licensing agreement. Um, so there are certain key licensing terms that one needs to know. So what would be those key license terms that you can put? For example, an ideal license agreement should talk about grants of rights. Who exactly is giving whom what? So which trademark is licensed? For example, you can own a business of for example, Bisleri, Parley, they make drinks, they make all kinds of drinks, soft drinks, hard drinks, normal water. So you may have multiple trademarks under one business setting. So, which trademark are you licensing? You need to pinpoint that, specify what trademark and which trademark are you licensing, and for what goods and services. Because in the discussion ahead, you'll realize that you can give a trademark, but you can also choose not to give that trademark for the same kinds of services also. So, for what goods and services are you giving it? Are you giving it for a certain all over India, or, all over the world, or are you giving it for a certain specific territory? And for what duration are you giving it? Like, is it going to be for 5 years, 10 years, 6 months, so and so, right? For example, a license might be granted for anything, let us say for 10 years or something. So that is what we need to decide in a licensing agreement, that what duration, what kind of license type is this? Is this exclusive? Is this non-exclusive? Is this sole licensing? Is this transferable in nature? Can sub-licensing happen in this? And so on and so forth. So remember, what grants of rights? You have to see what goods and services, what kind of territory you're using, what kind of, you know, trademark would a good or service be used for. So all of that needs to be seen. Secondly, understand it is very essential for a trademark owner to maintain a kind of discipline or a watch on the quality. This is why I was discussing in the beginning that why do we need a trademark? Because there's certain kind of quality, there's certain kind of characteristic that a good or a service has, and we are used to it. We feel that we can relate to it, and we have a kind of relationship with that subject, right? So while making licenses, while giving licenses for the same trademark, it is kind of a duty of the licensor to make sure that he or she still has that quality control over the goods or services, even while making a license. So the licensor must retain the right to ensure that the licensee's goods meet brand standards. This is again a very important clause that needs to be inculcated in the trademark license agreement. That make sure you do not give away all your rights as a licensor. You make certain clauses where you're able to cross-check the goods and services that are coming out of the licensee's workplace. And also because the license is given, when it is given, you make either a one-time payment or there's a consideration, right? Because it's an agreement. There also has to be consideration. That consideration again can be of two types. Either you take a one-time purchase, which is an upfront payment, or you do a royalties. So even to do that royalty, you need to know what kind of shares or what kind of profit the licensee is making. So to understand that also, you need to have access to what uh, good is coming out and what quality of the good is coming out. You need to perform routine audits or product samples. You need to taste and check if they are meeting the standards or not. So all of this can be done and can be put into the assignment as well. So this is the second point. The first one we again mentioned that there has to be a grant of rights. We specify what kind of rights we are giving and we are retaining with ourselves. And the second is quality control, and it goes both ways. While it's a duty of a person who is giving away the license to make sure that the quality of the good or service continues. Otherwise, it's a whole thing which is driven by the consumer. So if the consumer is not happy with the quality, it's going to go down the line. Again, third thing would be usage guidelines. How will you use my trademark? For what reasons will you be using my trademark? So specify exactly how the mark is to be used. If Fanta comes in a certain font, it is coming in a certain color, the font is having a certain color. So, logo, what kind of logo, what would be the height and breadth and length of the logo which would be used, what kind of colors would be used, all of this. So, all of this also needs to be put into the assignment as a usage guideline. Next is because it's an agreement where there's a consideration also, and because you're licensing, the reason why a licensor would license is also to make sure that the business grows and then they also make money out of it. So fees and royalty is also something which is very crucially a part of the license agreement. Define the payment structure. Will it be an upfront payment? Will it be an OTP, which is the one-time payment? Or will it be a percentage, like every time you have a profit of so and so, I will be taking 2% out of it? or all of that. So that also needs to be done. Just a tip here that try not to do the price fixing, because price fixing is a little anti-competitive in nature. So it invites competition laws to this. Lastly, I think so far what we've seen is that we're trying to understand what kinds of rights we are giving. We are trying to understand how do we determine the extension of those rights in terms of geography, in terms of tangible territories or intangible territories. For example, saying that logo needs to be used in a certain way, this and that. You also need to mention the duration and termination, because remember, this is not a thing which goes on and on and on. The licensor and the licensee have come into an agreement, which also will have an eventual start date and also the eventual termination date. So state the term of the license and conditions. Because in case of an early termination, you will have to see what kinds of, uh, you know, um, indemnification that you have to do. So include a post-term also that the license is only given for states of Rajasthan, Haryana, Madhya Pradesh, and it's given only for, let's just say, 10 years or 6 years. And you can also make some provisions that for the state of Rajasthan, so when so person is giving it for 6 years only, but for the states of Madhya Pradesh, I can give it for 10 years and all of that. So that is there. Next is what kind of liabilities you as a licensor hold towards the licensee in terms of uh, various circumstances, and what kind of indemnity does the licensee have for a licensor. The licensee should indemnify, and this should be an important clause in one of the agreements that you are making, that the licensee should indemnify the licensor against any form of misuse that he or she has made for the trademark. For example, if you have breached the quality rule, or if you have not made sure that the quality and the standards of the goods are to be maintained, and you have not maintained that. So what happens in those situations? So this clause will take care of that. And in a case where licensing damages the trademark's reputation or goodwill, or damages the, breaches the quality rule, and thereby causing damage to the brand itself, you need to clearly spell out which party is responsible up to what extent and for what reasons. So, and what happens in cases of a third party infringement, who indemnifies that? This also needs to be put. Like, it's not just a licensor or a licensee who can go wrong in a situation. You also have third party infringements of product liabilities that come into existence. So that also needs to be put into the agreement. Then the final stage, because these are the universal clauses that any agreement needs to have. Further clauses can be added depending on the specific and the personal and specific situation in which trademark handover is happening. But these are the universal clauses that one can put. The final thing would be to do the recording, in the sense that you're registering the license with the trademark office. So how do you do that? Again, as I said, there is a trademark application form, TM48, which you use, and an entry in the register is done, and then they, use it and cross-verify if there exists another trademark like that, and if there exists another assignment of licensing of this sort. So this provides you with the evidentiary value in cases of mishaps. So yeah, so this is mostly what happens in the licensing, that you provide the quality, you provide the exact things that a trademark provides, and you license it out to the licensee. So understand that never make a trademark license agreement which is very loose in its nature, or is, how do I say, it provides excessive freedom in terms of quality or in terms of control. So that should not be the case in a license. A license should be well drafted, and it should be well clearly spelled out stuff should be there. The language should be of ownership. You need to take care of the competition considerations, and then you also need to specify, because we just talked about universal clauses. We also need to specify what kind of what happens after termination. So, um, that also needs to be specified. So quality and control, kind of ownership, what happens in cases of termination, in early termination, competition considerations, all of that needs to be taken care of. So we know what we do have franchising and we do have licensing happening in India. You must be pretty much eating from McDonald's, you must be eating from Domino's, and you know that they are not the Indian companies, they've been franchised or leased out to us. And there's a certain way a pizza would be made in whatever Domino's shop you walk in, right? Even in the same city, if there are 3 Domino's stores, you walk into any of it and you realize that the quality is same and the considerations are same. So that's it. So I think this is fairly what we can talk about when it comes to licensing. Now we will just move to assignments. Like what do we mean by trademark assignments? As opposed to legal trademark licensing, where there was no giving away of ownership, assignment differs from licensing in that aspect. A trademark assignment is a legal sale of the trademark itself. Understand this? A trademark assignment is the legal sale of the trademark itself, as opposed to a licensing where there was a certain time period for which the trademark was given. That is, the right to the mark is given from one party to another. This is transferring of ownership. Unlike a license, an assignment conveys full ownership, subject to some limitations if they are agreed. Like, for example, I own a clothing brand and I have a specific uh, designs that I have with that clothing brand. My cloth is of a certain kind, and I have that cloth brought in from a certain place. So while giving away the ownership, I can put certain limitations like, you need to continue to bring your clothes from so and so place because that's what makes my cloth different from other cloths, and that's how I have my brand, and that's how I have a particular reputation. So yeah, so any limitations can be there, but unlike the license, an assignment conveys full ownership rights to the assignment. So, you can transfer all rights in a class of goods, or you can choose to only do a partial assignment. That is only for some goods. For example, I have a brand called Bikaji, let's just say. Now, in Bikaji or in Bikaner Wala, we have multiple commodities. We have sweets, we have namkeens, we have goodies, and we have other kinds of things that we come up with. So while doing away and while giving away the assignment, I can make sure that I only give you the stream of namkeen and not the stream of sweets. So this is a partial assignment. This brings me to another question, that what happens in a case where a licensing or an assignment is done, but there is no transfer of goodwill. So what do we understand by goodwill and what do we understand by reputation? If any one of you want to just take a quick guess in the chat box and see what do we mean an assignment with goodwill and an assignment without goodwill, or is there a difference between the goodwill and reputation in your head, or are they the same terms? Anybody who wants to take a guess at something? Goodwill is is a concept that grows over time. Um, if you see, a goodwill is not something which, if you open a shop today, and on day one you will have goodwill. I don't think so. That can be the case at all. Um, with goodwill, I think it's it's the slow process of continuously delivering a quality material consistently at a specific quality, at a specific standard. So then goodwill essentially becomes the commercial magnetism, which attracts the consumer, because the consumer or the customer knows that this is what I'm going to get in that shop because they have been consistent with this. So the commercial magnetism built over time through quality, through consistency, and through um, disciplined level of uniform level of service is what gives a shop or a brand goodwill. It takes time to be built, and generally goodwill is not separable from the business. It can be in certain cases, but generally it's not separable. And there is no positive or a negative goodwill. A goodwill is a goodwill, right? So, but goodwill is assignable, independent of the business. Which brings me to the second point, which is what is reputation? In order to understand what is not goodwill, we need to also understand what is reputation. How is reputation different from a goodwill? Reputation is nothing but the perception or awareness in the consumer's mind about a brand. They may or may not have used it, but they may have heard of it. And a reputation cannot exist independent of the business at all. A reputation cannot be sold off without the business, as opposed to a goodwill, which can be assigned. A reputation cannot be assigned independent of a business. And a reputation can be both positive or negative. Reputation, though, takes time to be built. It is not as consistently and slowly built as a goodwill. A reputation can be built very easily. It can be, you do one thing wrong and you have a negative reputation. You do one thing good, your reputation comes back to being a positive reputation. So this is what is the difference between the goodwill and the reputation, and how you can transfer and assign the assignment of a license, assignment of a goodwill and a trademark, and make it with or without goodwill. With goodwill, the trademark is registered along with its associated business reputation. Let's just say a Ferrari car. Now, if I take away the goodwill, essentially what am I doing? I'm telling you that you can use the term Ferrari, but you will not use it in the electric and motor vehicles. You will only use it for the unassociated category of services, unassociated category of goods. Your market should not overlap with my market, but you can use Ferrari for, let's say, Bhujia, or for making sweets, or for making a namkeen. This kind of assignment is known as assignment without goodwill. But if I allow you to use the term Ferrari for the cars, it will be an assignment with goodwill. Here, the assignee steps into the shoes of the original owner for assigned goods and can claim the benefit of previous hard work and goodwill, right? So this is to understand. So when you're making the agreement, make sure that you get the assignment with goodwill. Otherwise, the brand has to again start and make an independent goodwill and reputation of their own. So claim the benefit of the past use of the trademark and then reap the benefits of it. Again, without goodwill, it's something like the naked license. What is naked license? The naked assignment. In naked license, there is no quality check. Similarly, in a naked assignment, the mark is transferred without the existing goodwill, without which the mark is absolutely nothing. If I if I if I adore the mark of Ferrari, I adore it because it comes on a car. I will not adore it, or I will not feel assured for a mark of Ferrari if it comes on a packet of Fujia, because I know that's not their expertise, that's not their forte, that's not where they've spent their research and development. So, so, so this is what assignment is, and how you can assign. You can assign it with goodwill or without goodwill. Now, coming to legal procedure in India for assignments. So, Chapter 5 of the Trademarks Act talks about assignments, essentially Section 37, 38, 39, up to 40. They talk about how assignments can be done, rights of the assignee and assigners, and so on and so forth. The assignment again needs to be in writing and signed by the assignee. Someone who's selling the business, the trademark, needs to sign it, and this also needs to be in writing. For registered trademarks, again, because we made the distinction between the registered trademarks and the unregistered trademarks, the registered trademarks will be given protection and they will be registered at the registry using the form TMP, which is required for the for the thing. In assignment, the new owner's name is registered and the old owner's name is cut or strike. This is important. As opposed to licensing, they were just making a hold of the registration of licensing agreement. But in assignment, we need to make sure that the changes are made in the register. Again, for unregistered trademarks also, an assignment can happen. And that assignment again will be done in a different form, but that can also be done. So so similarly to what we had mentioned in the license, we also will be in the licensing, we'll also be mentioning in the general assignment agreement, the clauses would be universal except for territoriality and termination. There's no termination when it comes to assignment. So the agreement should clearly state whether the goodwill is included or not. Because if you don't mention the term goodwill, just remember a lack of mentioning can lead to disputes and it will be a basic application of legal principle that if it's not mentioned, it's not there. So, so yeah, that's there. I mean, some common pitfalls that can happen while making the transfers in terms of assignment or licensing is the naked licensing or the naked assignment that you just mentioned. That which actually disperses the entire purpose of having a trademark, which is to maintain the quality or to maintain the goodwill of the product. So if you're making a naked license and a naked assignment, you're taking away the quality and you're also taking away um, the goodwill. Again, unregistered mark is another pitfall because you don't know what decision the court will take based on the circumstances. You do have a protection, but you have a protection with the civil law, common law system, as opposed to having a protection under the trademarks law. So lack of documentation, so registry is important. So these are the common pitfalls that you can have. Um, Now coming to because we understood what licensing is and what assignment is, we need to understand why are we looking for monetization of trademark? Because these are the ways in which we monetize a trademark. So what is brand equity? In order to understand the commercial value of trademark, we also need to understand what is brand equity. Think about a store like, what people drink these days. Starbucks. Think about Starbucks. What kind of emotions and what kind of association do you have with Starbucks? Like, when you walk into that store, what do you feel when you have that famous grande or a latte, pumpkin latte or pumpkin spice pumpkin latte? What do you feel? You know that there is a certain quality that I'm expecting, there is a certain standard that I'm expecting. Um, and how do you have that? Because you have traced the product, you have seen the product on the social media, you have seen the advertisements of the products everywhere. So an old brand can choose to commercialize and gain reputation. This is called brand maintaining. As opposed to, let's just say, a new business starts in the liquid drinking company, and it's called, let's just say, this is Starbucks, that's called Moonbucks, and it's a very new company. No advertisement has happened. People have not tasted the product. So what comes to your mind then if you walk into a random store known as Moonbucks and you eat something and you drink something out of there and you're like, okay, the taste is not so bad, but you will not remember it and you don't have any kind of recollection of it. So, what is your relationship with that new store, Moonbug? It's nothing. This is what brand equity is. Brand equity is nothing but how well a consumer is aware of your brand and how knowledgeable a consumer is aware of your brand. Awareness is the first step of the brand equity. Knowledge is entirety of what do we mean by a brand equity. So how can you be aware? You can be aware even without drinking the product or even without using the product. You can just have the level of recollection about, you know, oh, this Starbucks looks like this. Oh, the spice latte, yeah, I've seen the machine. It looks like the glass. It looks like that. So you have a recollection of the product, right? But when it comes to the brand knowledge, you do not just a recollection. You have had a substantial relationship with the brand. You've tried the products. You know what happens, what kind of quality you get, and you're not just familiar with the brand, but you have a perception of the brand. You have a certain thought process for the brand and you have the attitude for the brand. So this is essentially what is called brand equity. So it refers to the economic value. Brand equity refers to the economic value of the brand or the trademark. It encompasses what the perceptions are, consumers' perception, how much loyalty does a consumer shows when it comes to a certain brand, and are they willing to pay the premium price for it, and how will they place the product, branded product over the generic one and all of that. For example, Nike's shoes, Coca-Cola's red label, they command higher prices because consumers trust their quality and that's why they're associated with this, right? And this brand equity essentially helps us to monetize our IP. Another way to monetize our IP is to value it. This is called IP valuation. IP valuation is something which needs to be done in order to monetize your intangible property and to have a market of its own and to further your monetary interests. Um, Brands can be worth billions, but if not put to right use or into the right market, or if not put the right tag into the brand, it's going to be the valuation, if not done correctly, it's going to be a market huge lost because you have not explored the market. You don't know, what kind of goodwill do I have? What kind of things do I need to take care of while making or selecting my evaluation? So, what is IP valuation? IP valuation is nothing but it is a process to determine the value of your intellectual property. While intellectual property is essentially intangible in nature, while making the valuation, you need to make sure that your property is tangible in some form. For example, if it's an assignment or a license, you would have an agreement. So that agreement would be the tangibility of your intangible property, right? Um, you need some kind of evidence to do that valuation. You need to know what kind of market your IP has. You need to know what kind of is, because you need to know if the IP is recognized. Is it legally allowed to transfer that IP? Can you sell that IP? Can you validly make any kinds of rights and duties and all of those with that IP? That is what is needed before IP valuation is done. So IP valuation is again nothing just to determine the monetary value of your IP, and there are certain ways in which we do that. Um, how do we do that? So essentially, there are certain factors that we look into before making a decision for IP valuation. The factors would be what kind of IP is it? Because not every IP is same and not every IP has the same market. So what kind of IP is this? Is this a trade secret which is very scarce in its availability, but the market is huge, and as long as the trade secret remains a secret, the potential and the profit coming out of it is huge. So while doing an IP valuation for a trade secret, you cannot do an IP valuation for a trademark, or you can't place them in a similar level. A trademark's IP valuation would be done in a similar class of trademarks, right? So you need to first make that kind of distinction. What kind of market do you have? It depends on the circumstances. It depends on the situation in which you are making that valuation. In what time was it done? What was the market like? Is it before COVID? Is it after COVID? Because the market has changed. Let's just say, just taking an example of COVID after it, and is your IP still well and alive and active and getting the same amount of money? Is your IP still relevant in the market, or you had an IP and your product was very unique, but soon a lot of other similar products came up, and now you know your IP is not as active as it was supposed to be. So is it going to get you the same kind of monetary benefits or not? If you're trying to purchase an IP from the other person, you need to do this valuation, and while doing that valuation, you need to check the market market requirement of the IP, and what holding or what position does that IP has in that market. Another kind of thing that you can look for is that IP replaceable, if it's state of the art or not, while making the valuation. If it's not state of the art, you make a lower hedge for it. Or at what or in what circumstances is the IP valuation done? For example, if it's a company and the company has been forced to liquidate to give money back, then the liquidation which is happening is not happening ordinarily. It is happening under the force. So at that time, the valuation would be dependent on the necessity of the person and not as opposed to the good negotiable IP valuation. Because if it was not, if it was ordinary liquidation, you wouldn't just make sure to get rid of it and somehow to get some money and pay back the things, right? So all of that also makes some difference when it comes to IP valuation. Now there are multiple theories for IP valuation. There are rules also, but there are three common IP valuation theories that exist in the market. There's a cost-based method, there is an income-based method, and there is a market-based method. Cost-based method of IP valuation is when you look at the product or a service that your IP gives, and you try to either replace it or reproduce it. How do we do the valuation? We see that, okay, an IP A exists, let me try to make A1 or A X. AX would be replacement and A1 would be reproducing. So if I'm reproducing that IP, is my investment still the same as it was when the IP was getting created? Will I get the same amount of profit? Similarly, when you're you're replacing it with the IP would be the same, the utilization of the IP would be the same, but maybe the outer character or something would change. So that is called replacement. So while replacing, what will you see? If the original IP was made in a different way, will it be cheaper for me or will it be expensive for me? Will it have more usage to it? Will it have less usage to it? So this is what we see in the cost-based method of IP valuation. That what if I replace the IP or what if I reproduce the IP? So replacement and reproduction of IP is what we look at while doing IP valuation. So that's one thing. Another thing is the income-based approach. That is, you see what income is generated by that IP presently, and then you see the predecessing, let us say, 5 years, preceding 5 years, and you make a future risk-based um, prediction, and you say, okay, so this is what it is getting me in 2025, in 2030, maybe this is what I'll get. So if that's good, then I'm going to be investing in that. So that is also another way of doing valuation. Third way of doing valuation is to look into the market. Is there still a market for this IP? Are there any other products that are present and are cheaper in trade? And will I be, if I will be taking that IP, will I be actually making a profit? Or, it's just maybe right now it's looking like it's going to be making a profit, but a few years down the line, it's not going to be the case because a lot of other products are also coming into the market. So, they are going to take over and they are going to be the ones. So this will not remain the state of the art product anymore. So you do a market analysis. There are two steps to market analysis. For example, you do the research and then you investigate and then you try to compare. And if you find that, you don't find the exact similar IP, then you try to find exact identical IP, then you try to find similar IPs. And if the variables are different in both the IPs, you try to lower down the variable and make sure that, because again, this is prediction based and probability based valuation. So you need to have the variables as same as common as possible. So that's another way to do the IP valuation. So yeah, so I mean, so far I think we have covered roughly what we wanted to achieve out of this, which is to understand the concept of trademark, to look into the licensing, to look into the assignments, and what to keep in mind um, while making the agreements, both in licensing, both in agreements. What are the common pitfalls that we can come across? Um, why is monetization important? What is brand equity? How does it help in monetization? And while doing monetization, we need to know what is the exact value of our intellectual property. So IP valuation is another thing. How is IP valuation done? What are the factors to keep in mind while doing valuation? What are the methods to do IP valuation? So one is cost-based method, one is market-based method, and one is the income-based approach. There are many more to it and many subdivisions, all the three branches, but this is the roughly what I could cover in an hour. So, so yeah, I mean, this is what it is. Let me know if you have any questions. Anything that you have that you want to discuss for let's just say about licensing or about agreements or trademark in general, the concept of trademark or how item valuation is done, what kind of valuation is done there, anything of that sort. Okay. I think Tazeen and Sanjay, I'm done from my part.
Thank you, ma'am. That brings us to the end of today's session for trademarks. And a big thank you to our esteemed speaker, Ms. Rajshree Acharya, for sharing their invaluable experience. And a thank you for all the active participation and insightful questions. Also, anyone can still ask questions if they want to. So, we hope you found today's session very enriching. We hope you have a very wonderful evening. Thank you, ma'am.
Okay, thank you so much. Okay, somebody has raised hands.
Yeah, ma'am. So regarding the IP valuation, are there any like different companies who provide who we go to, like can you do a valuation for us, like big four companies, or like who does that? And
So a lot of law firms, for example, Khurana and Khurana, I'm not monetizing anybody, but just giving an example, Khurana and Khurana, then you have Rajshree and Sagar, all the legal law firms that work in the area of IP can also extend IP valuation as a service to you.
okay, got it, ma'am.
All right.
Yeah, thank you.
Anybody else?
And for startups, is there? Do you think is it any? Do they do any for startup companies? Like generally, I'm just
Yes.
asking like.
As opposed to a stagnant general business, we also have a different kind of valuation system in place for startups. Again, none of them are fully corroborated or fully 100% sure. It's based on probability. But yes, for startups also, we do have IP valuation, and all the law firms who are dealing in the intellectual property rights would be doing it.
Okay.
All right. All right, Hazeen. All right, Sanjay. Thank you so much. Have a good day. All of you have a good Sunday. Bye-bye.
Yeah, thank you, ma'am.
Also, everyone, due to some technical error in the platform,